All right. I hope that everyone is caffeinated and, oh, Tony Morrow's here, so we can start. Okay, that's what we were waiting for. Don't tell Tony. Good morning, everyone. Thank you so much for joining us on this rainy morning. Thank you in the audience here, those watching the live stream, and thank you especially to our esteemed panelists. This is the third annual Home Stretch at the Supreme Court event that CAC has put on here at the Press Club. And the first year there was flooding. Last year I think it was sunny, and this year it's just raining. So I feel like that's kind of a wash. But thank you all for braving the treacherous conditions. You know, the other sort of tradition, other than just crazy weather when we have the Home Stretch event, is that every year I say, this was a big term. This was a blockbuster term. And then the next year I'm like, no, this one is a big term. So I feel like I'm kind of tempting fate here because, you know, I don't think any of us want to be here at the fourth annual Home Stretch event talking about how an equally divided 4-4 court decided Trump versus Clinton and the 2016 election. But I will say that this is a really big term. You know, you think about when the term opened, the cases that were before the court or which we likely expected to come before the court and did. We have the Fisher versus Texas case making its second appearance at the Supreme Court, and the question of race-conscious admissions policies in undergraduate admissions. We have the abortion access case out of Texas, religious liberty and contraception under the Affordable Care Act, public sector unions, immigration, criminal justice reform, such as, you know, whether or not you can have meaningful prohibitions on peremptory challenges that are exercised on account of race. There are a plethora of incredibly important cases up before the court this term, also issues about voting, which brings to mind the fact that this term is happening right in the thick of a hotly contested presidential election. And the themes that we see before the court this term are echoed in the public debate around the election. How far we've come and how far we have yet to go to achieve true racial equality and meaningful justice for all. Religious liberty claims, particularly when they run up against protections and guarantees of equality and generally applicable laws, anti-discrimination laws. What to do with immigration and the fact that we have millions of hardworking families here that have US citizen children and maybe parents who are here without documents. We have questions of voting itself, whether that right can be cast free from restrictions like voter identification, and also whether everyone counts for purposes of democracy. These questions are being debated by the country in the election, and they're also before the court. So this was going to be a major term, both for the public, for Supreme Court watchers, for the justices, and then, of course, in the middle of February, there was the passing of Justice Scalia. And that made what was already a blockbuster term an extraordinarily important year for the Supreme Court. Questions obviously were raised initially about how Justice Scalia's absence from the court would affect the court itself. Big questions about jurisprudential shifts, but also sort of more nuanced questions about how his absence from the courtroom, he was a very active questioner, would impact those interactions from the bench and with the advocates. And then, of course, we switched to thinking about the institution itself and how the vacancy would affect the Supreme Court, with Senate Republicans immediately starting to claim that they would refuse to even consider, much less give a hearing and a vote to the president's nominee. We're looking at the potential to have a less than fully staffed Supreme Court for not just the rest of this term, but potentially all of next term. And that means you could have up to, 120 or so cases that are not decided by a fully staffed 9-justice court. And that impacts or threatens to impact the profoundly important work that the Supreme Court engages in for the country, deciding both important questions of fundamental rights and also settling disputes so that we can ensure that there's one law that applies across the country, not based on which circuit you live in. So the Supreme Court needs to be able to do its work properly. But I think at this point, even if the president nominated Mitch McConnell, he probably wouldn't even give himself a hearing and a vote. So these are the questions that are before us today. They're important substantive questions of law, important questions about the court, and I'm delighted that we have this amazing panel to help us make sense of all of them. I will hand it over to Amy to introduce our esteemed panelists, but first I would like to introduce Amy Howe, who is our fabulous moderator today. Amy is not just the editor and contributor of SCOTUS blog, the preeminent Supreme Court blog that we all turn to when we need to figure out what is going on with the Supreme Court, but she's also herself an accomplished Supreme Court litigator, having argued cases before the court, been counsel in dozens more, and having taught Supreme Court litigation at Harvard and Stanford. We are incredibly lucky to have her and delighted to have all of you here today. So thank you again for being here. Thank you for listening, and I look forward to this great discussion. Thank you, Amy.
Thank you, Elizabeth. I am delighted to be here on a purely selfish matter because Kelly and her team have put together such a great set of 4 panelists, and as the Supreme Court enters its home stretch, I get to benefit from their wisdom as much as the rest of you. I'm going to go through in alphabetical order, starting with John Elwood, who was an assistant to the Solicitor General, and I'm just going to sort of cover the highlights here, introducing them, because if we went through each of their resumes, we would be here all day because they're also accomplished. But John Elwood was an assistant to the Solicitor General, Deputy Assistant Attorney General in the Office of Legal Counsel in the George W. Bush administration. He's now a partner at Vincent & Elkins and an instructor in the UVA Supreme Court Clinic. We have Brianne Gorod, is that, I'm sorry if I'm, okay, who was a clerk for Justice Stephen Breyer and a member of the Supreme Court practice at O'Melveny and Myers before joining CAC and is now chief counsel. Sherilyn Ifill, who wears many hats. She is currently the director and general counsel at, did I get it right?
President
and director counsel. I knew there was a director and a counsel and a hyphen in there. I'm sorry. President and director counsel at the NAACP Legal Defense and Education Fund. She's also a law professor, an author, and a nationally recognized expert on voting rights. And then next to me is Andy Pincus, who is a partner at Mayer Brown. He was an assistant to the Solicitor General and is the co-director of the Yale Supreme Court Clinic. He also argued Spokio versus Robbins, among many others, which is one of the cases that we'll be talking about today. And so Elizabeth mentioned that this is a big term. Last year, at the end of the October term 2014, there was a lot of discussion about how there were victories for the liberals in that case, and sort of the subtext or sometimes the overt text and a lot of the commentary on last term was wait until next term when the pendulum may well swing back in the other direction. But in some of the decisions that have come down so far, some of what looked like they could be big cases arguably turned out to be not so big cases. And so I want to start with what some people refer to as the consumer trilogy. There is Tyson Foods versus Buefacchio. As many of you know, in 2011 in the Walmart case, the Supreme Court said that a nationwide lawsuit by female Walmart employees couldn't go forward. But in Tyson Foods this year, they ruled by a vote of 6-2, I believe, that a lawsuit brought by a group of workers at an Iowa slaughterhouse for overtime pay could go forward, even though they were going to try and use representative evidence to establish liability. The next decision that the court has issued, I think it was also 6-2, was Campbell-Ewald versus Gomez. And in that case, the court said that a lawsuit could go forward after the defendant had offered the lead plaintiff everything that he was asking for. And then the third case was Andy's case, Spokio, and that is about whether or not Congress can authorize a lawsuit by a plaintiff who has not suffered a concrete injury. And so my question for all of you, and I think we'll start with Sherilyn and then we'll move on to Andy, and if John and Brianne have something we can hear from them as well, is what does this, first of all, were these in fact big cases? Are there any trends that we can read? Is the court, having issued the decision in Walmart, now saying, but that's as far as we're going to go? What's going on here?
Well, first of all, thank you so much, Amy, and thank you to CAC. I guess I would only focus on Tyson Foods for a moment because, frankly, we were from a civil rights perspective, very focused on that case because of Walmart versus Dukes. And obviously, when we're talking about large class actions brought on behalf of workers and a large number of workers, it's critically important to be able to hold the class, and Walmart versus Dukes was a real blow. This was a case that involved the desire to get recoupment for overtime pay for the time that employees spend donning and doffing, taking on and off safety equipment that's required by the employer to be worn in the job place. So this was a pretty important decision from our perspective, and frankly, we weren't sure what to expect. We expected something that might be consistent with Walmart versus Dukes. So we were rather pleasantly surprised by the decision, but I think it would be hard to think of it as a trend or necessarily leading anywhere, because I think Justice Kennedy was very careful to talk about the narrowness of the decision and to reaffirm Walmart versus Dukes and to say this does not touch Walmart versus Dukes. Nevertheless, it at least provides an opportunity for plaintiffs to be able to present a case of the kind that was presented in Tyson Foods using representative evidence, which is really in many ways the only way you can litigate those kinds of cases. So it was helpful, but I would hesitate to call it a trend.
The defendant in that case sort of boxed itself in because there was no evidence.
That's
there
right.
were no records.
They had not kept the proper
and
records.
So
that would
it's
allow
hard to
them.
say they can't use representative evidence
That's
if
right.
there's no evidence at all. Andy, do you have?
Yeah, I think that's a really important point. I think that some people sort of had a caricature of the court that, any class action case that was presented to us, it was going to rule in favor of the defendant. And I think these cases show that's not true. I don't think that they've sort of abandoned, that they're not going to rule in favor of the plaintiff in every case either. I agree with Cheryl, and these were pretty narrow decisions. And in the Tyson decision in particular, as you say, it was very tied to both the specific facts of the case, what records were available and what weren't, and the specific statute, which had been interpreted to allow this kind of evidence when the employer didn't keep records that were required to be kept by law. And so I think from the defense perspective, although that defendant lost, the opinion said some things about the use of statistical evidence, which is sort of the critical question in the case. When can you use statistical evidence to prove an element of the claim and therefore establish that that particular issue is common to the class and not individualized, and therefore allows is one step on the road from the plaintiff's perspective to allowing the class to be certified. And the court said, we're focused on the substantive law here. We're focused on the fact that the use of the statistical evidence didn't preclude the defendant from presenting defenses that it might have as a matter of law. There's been a big concern in some cases that the use of statistics precludes defendants from introducing plaintiff-specific evidence that might protect it from liability. And I think you'll see those themes elaborated on in subsequent cases. So in this case, the class challenge was rejected, but some legal principles that may allow some defendants to prevail in subsequent cases.
Are there cases in the pipeline that could be heading back up?
There are. It's the ability to take appeals in class cases, and the number of class cases that are brought is sort of always going up and down. And I think there may or may not be cases in the pipeline because, of course, in a lot of cases now, both sides may be going back, depending on what the decision was, to say, as a result of what the court said in Tyson, either now our class should be certified, or now the defendant may say this gives us some tea leaves that say the class shouldn't be certified. So my guess is you're going to see some litigation. The court had a couple of cases in the on-deck circle at the time it decided Tyson and didn't grant cert in those. So I think that may be some indication that the court also wants to sort of see what happens as it did at Walmart and not sort of jump right back into the fray.
Although for that, I was disappointed, as a defense side guy, I was disappointed that those cases in the on-deck circle weren't granted because Tyson Food was kind of an idiosyncratic choice because it involved, Fair Labor Standards Act, and it involved bad record keeping and kind of an unusually small and compact class, for modern day class actions. And so there's another Walmart case lined up behind it, and they didn't take that case, even though I think it would have provided more general guidance about the use of statistics. Also, because it turned out like the petitioners in Tyson Food didn't want to, they basically didn't make the argument that they made in the petition on the merits. the court wound up not reaching that. And even though it recognized that it was an important question in its opinion, it didn't take this Wells Fargo case that was lined up behind it, which is kind of a disappointing thing. And I think we'll be getting into more of this later, but it is kind of perhaps an indication the court didn't want to wade into these waters with less than a full bench.
Yeah, I think it's interesting to think about this term's cases, against the backdrop of the first decade of the Roberts Court. I mean, as Andy said, maybe a bit of a caricature to say that, defendants always win and plaintiffs always lose in the Roberts Court. But this is a court that has been very favorable to big business and to corporate interests in its first decade. I mean, the proof is in the pudding. You look at their record, the Roberts Court, the chamber win rate, the success rate of the Chamber of Commerce in front of the Roberts Court has been 69%. That's markedly higher than it was at the end of the Rehnquist Court when it was 56%, and significantly higher than it was at the end of the Berger Court when the chamber was winning at a rate of 43%. So, I mean, this is a court that has been, very consistently voting in favor of big business. And what I think we saw this term, and I think it's interesting, as Amy mentioned, these weren't 5-4 or 5-3 decisions. Campbell-Ewald was, I think, 6-3. Tyson Foods was 6-2. So you had not only Justice Kennedy, but Justice Thomas and Campbell-Ewald and the Chief Justice in Tyson Foods, voting to reject businesses' claims. And I think it's a real sign that this term, business interests, maybe went a bridge too far and went places that even some of the very conservative justices on this court weren't willing to go. And I think even if these cases were narrow, that's a really good thing, because what we've seen over the past decade is the court consistently making it harder for individuals to get into court and making it harder for individuals to vindicate federal rights that Congress has created for them. And so it will be really interesting to see, I think, what the court does in future cases and where exactly it draws the lines.
Okay, you have set up our next set of cases quite nicely. You talked about how those cases were 6-2. Two cases that were unanimous were two voting rights cases that were decided recently. And I think going into the term, I think there may well have been a lot of apprehension on the part of voting rights groups, because if the court had ruled for the challengers in these two cases, it could have been a really seismic shift in how states draw their legislative maps. And it turned out that in both cases, the court ruled unanimously against the challengers. The first case was Evenwell versus Abbott, which was a one-person, one-vote challenge to Texas's legislative maps. They argued, the challengers in that case argued that legislatures in that case, when they draw the legislative districts, should use registered voters rather than total population. The other case was a challenge to Arizona's redistricting map. The argument there was that it was the result of partisan gerrymandering, and the Supreme Court in that case said no, they were trying to comply with the Voting Rights Act. By all evidence, there may have and that's fine. The court in the Evenwell case said no, the state can use total population. It doesn't have to look at registered voters. And so my question for you all is, were these big decisions, were they sort of one ticket only? Are we going to be hearing more from them down the line, or was it sort of from the perspective of voting rights groups dodging a bullet?
Well, I think, and I would love to hear from some others on the panel, their view about why the Supreme Court took the Evenwell case, which was a fairly astonishing theory that that the state was prevented from using total population and needed to use voting age population or eligible voter population for purposes of redistricting. The use of total population has been described as a kind of national redistricting policy. And so the idea that we would now upend this critical principle of redistricting and restrict those who were counted to those who were eligible to vote is kind of astonishing. I mean, if you can imagine, if we did this, 100 or so years ago, we would not include women in redistricting because they weren't eligible to vote. And so, of course, we filed an amicus brief about the way in which this would affect redistricting by excluding ex-offenders in states where they're unable to vote. It would exclude children, 75 million children, and so forth. And so it seemed kind of strange for the court to have taken the case, which is what made us nervous, because we thought, why on earth would they take this unless they actually thought this made sense? Sitting at the oral argument, I have to say, the argument did not allay my fears. It was a strange argument in which the court seemed to actually be giving credit, at least some of the justices giving credit to the idea that this was a credible question that we ought to be grappling with, and that it was even a close question. So I did not leave the oral argument feeling calm. I felt actually more alarmed than I had felt before. So we were absolutely thrilled by the decision. And I think, you read in Justice Ginsburg's decision, even Justice Thomas's, we still haven't figured out why we use one person, one vote. There was a kind of a pragmatism to the decision. A lot of it was about kind of the history of what, how we arrived at total population and what has been the practice and what the kind of upending it would do to change the practice. So I do think that the court was united in a pragmatic sense that this was, I think you used the term a bridge too far. I don't think in any way that this presages the court's unwillingness to venture further into the voting rights space. I think they will not have a choice considering the voter ID cases that are coming up through the pipeline, certainly our Texas case, the North Carolina case, and others. They will have to deal with that issue. But I didn't feel that the Evenwell decision was an indication of where they are on voting rights. I thought it was an indication of kind of a pragmatism, but it still leads me back to the question of why they took the case in the first place. And then I would say for Harris was actually in some ways the more interesting case because this was the question about whether, if you were trying to comply with the Voting Rights Act, you could redistrict in this particular way. And that was particularly important to us because I think it potentially opened the door to further weakening the Voting Rights Act, which of course the Supreme Court did in 2013 in the Shelby case. So that decision actually in some ways was more important. And there I was very pleased to see, again, the kind of unanimity of the court on that issue. And we've been talking ourselves about how to read that decision as well. And I'm not really sure. I have some alternative theories about what might have been going on in that case. But again, I would say even with these two cases, because they would have represented such a huge shift and such a huge upending, I don't think we can say that this means that now the court is reticent about entering further into the voting rights space. In fact, I think that there are a number of justices, and the number remains uncertain, but certainly 4, who are quite interested in doing so.
Anybody?
Well, I was just going to say something about Evenwell. It seems to me that you never know what's going on, but Texas certainly made quite a point in its presentation of trying to get the court to rule that either option was permissible, either whole population or voter eligible population. And if you were maybe not even a paranoid person, just a concerned person, you might think that might
Doesn't mean they're not out to get you.
that might have been an effort to lead to a situation where states had options, and then some states who, for political reasons, since as everybody can see, redistricting is the most political decision making that goes on because it's about the legislators themselves. Could have led some states to choose the voter eligible population approach, and that would obviously have had lots of consequences. So the court didn't address that issue explicitly, although, and Sherilyn's infinitely more expert than I am on these issues, I think Justice Ginsburg's opinion sort of indicated that would be a tough position for the next case if it were to come to advocate. But I think that's certainly something that was lurking in the background of the case, and whether it had to do with the question of noting jurisdiction or not, I think it was certainly hovering around there.
I think that there is something going on here. This is one of these cases that I don't think was always a unanimous vote. If you look at Justice Alito's opinion, he says, I would only hold that blah, and that's what the court actually held, which reads more like he was, perhaps dissenting or a concurrence in the judgment, whatever, from an opinion that did say it's got to be total population. And when you count the votes, if the chief and Kennedy had dropped out, I think there would have been 4-4, assuming that it was on the other side of the judgment. And so it could be that it started out as it's got to be total population, which, if it makes any sense, maybe gets Scalia's vote. Who knows? But that afterwards, in order to make things tidy, they said, okay, well, we'll just decide this one thing. You can keep your opinion, which throws all sorts of roadblocks in this way, and keep going. But one other thing, and this came up during the last one of these that Amy and I did, was that I am told, but of course I never bothered to look it up, that the chief, when he was in the Solicitor General's office, filed a brief that suggested that either option was okay. So that's one thing that'd be interesting, if that actually reflected his own views as opposed to the views of the George H.W. Bush administration. It may be something that he was trying to defend with his vote, but they've left that matter for another day.
One thing about I'm sorry, just a little factoid from a prior life about the about the voter eligible population, and I think the amicus briefs brought this out, but there is no reliable data for those numbers. In fact, the census doesn't count those people, and I think that is a real obstacle. And my guess is that the court, once it sort of saw the expert filings about that I wouldn't be surprised if that had a big impact, because statisticians and people who are in the population business will tell you that there is no reliable data now, and to get reliable data would be virtually impossible.
I think I agree totally with that. And I think, it's the question of why the court took it. And I believe this came up from a 3-judge district court. And, I think what this may indicate is that in cases that come up from a 3-judge district court where there's, what's called mandatory jurisdiction, the court doesn't have the opportunity of just saying nothing on the case. It has to either kind of summarily affirm or summarily reverse or hear the whole case. They're going to be more likely to take the case and do full briefing and really give it considered attention. But even more generally, I think it's probably a good reminder for everyone that we shouldn't read too much tea leaves when the court takes a case as to what it's going to do. I mean, I think particularly, last year in both King and ICP, the fair housing case, there was a tendency to really say, the writing's on the wall when the court decided to hear the case, and then cases didn't necessarily come out the way some people thought that they would. So just generally,
that's different. I'm going to put ICP in a different category, because ICP can't be seen alone. Right. That was the 3rd time that the court was making an effort to get
that's true.
But there was no circuit split on the issue.
I think our paranoia was well warranted in the ICP case. There was no question that there was a real issue to get at this question of disparate impact, under the Fair Housing Act, and I think that was an instance, unlike Evenwell, because I think you're right, although I still don't understand what's happening in oral argument. But in Texas versus ICP, that was a case in which the court had shown a consistent desire to get at this issue, and you heard it at the oral argument. You heard Justice Alito at the Texas oral argument really almost saying that what happened to these other cases? How did you manage to elude us? So I think that was a different circumstance in which it wasn't entirely clear what was going to happen. And I would say, in the Texas case, we're going to the last term, but my own sense was that there was a lot happening over the course of that term that I think may have influenced the outcome of that case. I don't think it was fait accompli the way it turned out. I think that was a nail-biter pretty much up until the end.
Oh, I totally agree with that. But it's just a good reminder, right? It takes 4 votes for the court to hear a case, but they need to get 5 votes. And in that case, whether it was things that were going on in the country or the strength of the arguments that were made, the 4 who I think you're absolutely right wanted to get at that issue couldn't get the 5th vote they needed. Right. And then the other thing, just going back to Evenwell for a moment, that I think is really interesting about that opinion is the extent to which Justice Ginsburg really relied on the text and the history of the Constitution. I mean, it was really, an originalist opinion. And so at a moment when we're kind of thinking about Justice Scalia's legacy for the court, I think it's a really powerful reminder that, he has changed the way we talk about and think about the Constitution in a way that applies to both conservatives and progressives. And it's a really powerful reminder that, the Constitution's text and history can produce progressive outcomes, as I think Justice Ginsburg really forcefully demonstrated in her opinion.
I think John would like
to.
A
plug for our hosts is that there was a source that was used in Justice Ginsburg's opinion that only appeared in the CAC amicus brief.
Right.
So, credit to David Gantz, who was the writer of that
but,
brief.
One thing, I didn't think Evenwell, from the beginning, I didn't think Evenwell was going to change the law that much, because I just thought there was too much of a history in favor of the total population thing. But I thought Harris had much more potential to change the law. It wound up being a much narrower decision, I think, partly because of Scalia's death. But there was, I thought that there was there was a very, I thought, compelling dissenting opinion in the 3-judge district court below, arguing essentially that, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race, that you should not, in order to the idea that you're going to expand minority voting by, essentially discriminating and packing, white Republicans into districts and, spreading out the other districts. And I thought that there was a very real chance that they would say that that is never a legitimate enterprise, purposes of getting preclearance from the Justice Department. And of course, that disappeared with Justice Scalia's death, even if they could have gotten Justice Kennedy on board for that. But it's interesting. It wound up being a very, very discreet opinion, very narrow, unanimous. But one thing that's interesting to me is that it was argued a month before Justice Breyer's opinion, which came out, and it came out a week after Justice Breyer's opinion that had a dissent. So something I think was going on in Harris. If any of us live to 120 or so and are around when these papers are actually released, we can look in the file and see if that was actually a unanimous vote all the way through. I suspect it was not.
All right, turning to another case on the court's docket this term that was a nail-biter to the end the last time it was around. Fisher versus University of Texas at Austin. I mean, the one thing we do know is that we will presumably get some sort of decision because with the death of Justice Scalia, it's now a 7-member court deciding Fisher. So anyone?
Well, let me just start, but I'm sure
Yeah.
I want to say something else. So this is the second go-round with Fisher, and it's obviously interesting. There is a very live, or at least should be live, standing issue in Fisher, which still has not been able to get much traction with the court. So it's always interesting when I hear, at oral argument, all the standing questions in some of the other cases recently. So there's a real standing question. But, this is the second round with this case, and I have to say that, we felt fairly confident. We had a good decision below, and we felt fairly confident going into the court with our briefing and with oral argument. And what was interesting to me, was that, of course, the attention in the argument really focused on Justice Scalia's comments, which is why it's kind of ironic that he will not be part of the decision-making in the case. But much of the focus was on the comments that Justice Scalia made about African-American students and that maybe they should be on a slower track or go to a lesser school. And I have to say, it was a pretty difficult thing to sit and hear because we'd actually brought our clients who are African-American students from the University of Texas from Austin to hear the argument. They were so excited to, some of the most impressive people you've ever met, their first time being in the United States Supreme Court. And I say that because I actually think it's important for people to remember that those moments matter. I know we all say oral argument doesn't matter, but it actually did matter to those young people to be there at that moment. So there was all that attention on Justice Scalia's comments, but actually I did not think it was a bad argument. I thought the argument went fairly well. And one of the things that Justice Kennedy focused on, which I think is worth remembering, is that he said this case looks like it's in the same posture that it was in the last time it was here, which kind of it is. And so there is this question about whether we need a remand back. I mean, the state really raised all of these questions about the affirmative action plan and how it's used, and it's actually amazing to me that they asked so many questions because we have ad nauseum gone through the details of this plan. But they were quite interesting questions. And I think they really pushed us to the point of kind of Justice Kennedy's question, which is, shouldn't we just be remanding this to answer those questions? You fought the remand, Texas. Why don't you just let it go back if you actually really have all these questions about the way this affirmative action plan works? You should know that, LDF, we have tried to intervene in this case, and also important to recognize that in all of these affirmative action cases, very often civil rights groups are not involved, and certainly African-American students are not involved. We have tried to intervene in almost every case, beginning with Bakke, and been denied. I think the only case we were permitted to intervene in was Grutter. So if there is a remand, we will be returning to the issue of intervention once again to try and flesh out the record. But we certainly think the record here is perfectly sufficient. As I said, I thought that the argument was a good argument, even though all the attention was on Justice Scalia's comments. Obviously, let's not pretend the focus was on Justice Kennedy. And Justice Kennedy's questions, I thought, went to how is this case any different than it looked the last time it was here? And we told you the last time it was here what we thought. So that is a nail biter, though, because we are going to have a decision, and we will see what happens.
So this was an interesting case because ordinarily 4-4 nothing gets decided, but this is a 4-3 case potentially. And the question for me is, where are the 4 votes going? Because Justice Kennedy did have this view or expressed this view at oral argument that didn't seem to be getting any traction with his brethren on the right, that maybe it's time for another remand. I I don't know where this is going to go. I would be kind of surprised almost if this winds up being that consequential a case, because I think the Chief Justice may feel a little bit chary about having much decided by a 7-member court, a 7-member divided court by a single vote. Maybe I'm wrong about that. We'll see. The last thing I have is that Justice Kennedy already has one opinion from that sitting. Somebody's going to have one extra opinion because of Scalia's death. But the Chief doesn't have any yet, and the Chief didn't seem all that enamored with this idea of a remand. But again, I don't have any idea either. But I think we will all say it's obvious in July.
I think this point about whether the court is willing to do something very controversial with a 7-member court on this question. I mean, there's a lot of obviously attention focused on this case, and I think that's not irrelevant to the question of how this comes out.
Do you think it's relevant that the justices are quite aware that there are other cases in the pipeline challenging the University of North Carolina and Harvard, and so let's just all make this case go away somehow? And
well, it's interesting. Fisher gets less consequential every time it comes around, right? So I do think that this kind of errs in favor of the remand. Like every time you do this, it becomes less of a consequential case, and it may be that what the court wants is to gather this all together, right? Because you've got these 2 other cases, as you quite rightly point out, that have been stayed pending Fisher, and so it may be that having all of these cases together will actually pull out what the court wants to say, particularly what the conservative justices who have been against affirmative action want. They may not be able to get what they want, frankly, out of the University of Texas system, because this was a case in which you actually had the top 10% plan that essentially didn't produce the diversity that they expected. So it may be that what they would prefer is to have another case that provides, or other cases that provide other factual presentations of the issue that they think may be more amenable.
And you could have a 9-member court
And
by then.
And heaven knows you could have a 9-member court. Wow.
What a novelty.
You still have 8 justices, though, on the case.
But the University of North, I guess if you kept Texas out of it,
If you kept
the
Texas out,
Carolina
that's right.
and the Harvard cases.
But I don't know. I think the other thing that's going on is if you look at the country, I think there was a long period where people, believed that, you could just get beyond race by not deciding based on race, as the Chief Justice said. But I think a lot of recent developments in the policing context, and especially the really amazing evidence that cameras have provided about what happens in the real world, show that we really haven't come close to getting beyond race. And I just wonder if the sort of outside world pendulum of, the time for affirmative action is over and we don't really have these problems anymore, may be swinging in quite a different direction given what we're learning about what happens in the real world.
Well, Andy, I think you're right, and that's why, going back to Texas, if you read Justice Kennedy's decision in the Texas versus ICP case, where he was talking about segregation and the continuing need for integration, I do not think that was unrelated to the year of 2014 and what we were seeing, around the country. It would have been a very bizarre thing for the Supreme Court to be striking down a major civil rights statute, the civil rights statute that was, enacted a week after Martin Luther King's assassination, in the midst of all of the tension that we were in during that year. And I think the same is true for voting rights. I think the court took a stand in the Shelby case, decided that case, I'm going to say it incorrectly, and I think that the results after the Shelby case have actually called into question that decision in ways that that I think have to give the court pause. I don't think it's necessarily changing the mind of the conservative justices, but I think when we look at cases like Evenwell and Harris, and the court has to think twice about whether they want to, enter this space in a way that is much more expansive than they need to. I think they have to make some careful decisions about how they pursue some of these matters. So I don't think it's unrelated, and when we get to talking about criminal justice, we can talk about that even more.
All right. We talked about the possibility of a 9-member court. I'm sorry, you have to listen to my strained segues from topic to topic. But right now, we've got an 8-member court. And so, clearly there are cases. I know you're all hanging on Hawkins versus Community Bank of Raymore, the first 4-4 tie of the post-Scalia Roberts Court, and then, of course, the 4-4 tie in Friedrichs versus California Teachers Association. So I'd like to start with Friedrichs and then move on to two cases that haven't been decided yet, but have the potential, at least if you go on oral arguments, to have the prospect of a 4-4 tie, Whole Women's Health, the Texas abortion case, and University of Texas, the immigration case. And so, Brianne, I'll start with you. Is 4-4 the new 5-4?
I think it's not clear that it is. I mean, I think, it was interesting. Immediately after Justice Scalia passed, we saw a spate of news stories that looked at all of the terms, big cases through the lens of the vacancy and the possibility and the consequences of 4-4 decisions in those big cases. And that was a totally reasonable approach. But I think, what's important to remember about those cases is I think, Justice Scalia was not likely to be kind of a deciding or key vote in a number of this term's big cases. And if you look at them, I think, it's very likely we'll actually see, outright wins in those cases, even with this 8-justice court. So, taking Whole Women's Health as an example, I think if you, look at oral argument, there were real indications from Justice Kennedy's questions. Justice Kennedy, I think, likely to be the key vote there, as he so often is, that he, understood that Texas's argument that courts, shouldn't look behind the asserted justifications for these abortion restrictions, that they, shouldn't assess whether these purported health regulations actually advance women's health, that those kind of arguments are just flatly inconsistent with not only the Constitution, but the Supreme Court's own precedents. So I think, there's a real chance that we'll see, an outright win for, striking down those abortion restrictions on Whole Women's Health. Taking United States v. Texas, the immigration case. Going into argument, I thought there was a very good chance that Justice Kennedy and the Chief Justice would both be votes for the administration. I mean, if you think about the Chief Justice's past votes in standing cases, he has consistently and very forcefully advocated for limited standing and for closing the courthouse doors. And it would be quite a stunning thing, given those past votes, if he were to say in this case, oh, let's throw the courthouse doors open, let's let Texas sue, and then we're to vote to invalidate the president's immigration actions. And of course, Justice Kennedy wrote United States v. Arizona, and the Chief Justice signed on to it, the case from a couple years ago in which the court recognized that the executive branch enjoys significant discretion when it comes to immigration and with respect to removal decisions in particular. And then, oral argument, there was a lot of talk afterwards that this might be a 4-4 decision. But I think, when you look at the argument as a whole, there were questions that both the Chief Justice and Justice Kennedy asked that I think, really suggest that they could well vote for the administration. I thought one thing that was particularly interesting about the argument was the extent to which it highlighted how Texas's position in this case has really shifted over the course of the litigation. I mean, at argument, it essentially conceded that deferred action itself is lawful and focused instead on the fact that deferred action recipients can apply for work authorization. But of course, as the Solicitor General pointed out, that derives not from the Obama administration initiatives, from regulations that date back to the Reagan administration. And Justice Kennedy, asked a question at the end of argument about whether Texas didn't challenge those regulations in this case, and whether they should have brought a different type of suit to challenge those regulations. So I think there are a lot of indications from argument that case too probably won't be a 4-4. That said, we have had, as you noted, a couple of 4-4 decisions already. I'm sure we might see others. But I think focusing on the pure number of 4-4 decisions has the possibility of understating the significance of what it means that we have an 8-justice court. I think you have to look at what the consequences of those 4-4 decisions are. In the Hawkins case, it was a low-profile case. People may not be paying a ton of attention. But it left unresolved a circuit split. And so, as a result of the court's inability to decide that case, you have different people in different parts of the country being subject to different laws. And a big part of what the court is supposed to do is resolve circuit conflicts and make sure that there's one uniform rule for the entire country. If you look at Friedrichs, about the constitutionality of fair share arrangements in public employee unions, this is a question that, frankly, I don't think there should be any legal uncertainty about. The Supreme Court decided that issue nearly 40 years ago and said they're constitutional. But, Justice Alito called that decision into question in some recent cases. Conservative activists brought this case, and they've made clear that they are going to continue litigating this issue until we get, definitive resolution from the court. They've in fact filed a petition for rehearing in Friedrichs. They're asking the court to hold the case and re-argue it once there's a 9th justice. The court's actually considering that at its conference tomorrow. In their petition, they noted that there's a handful of lower court cases that tee up the issue. And so there's going to be continuing legal uncertainty about this question until we have a 9-justice court that can definitively resolve the question. And then just one other thing, looking at the 4-4 cases, of course, doesn't tell us about the cases in which the court maybe didn't come out 4-4, but didn't do what it would have done, had it had 9 justices who could reach an outright majority. And I think, what we're also seeing here this term is the court potentially struggling and trying to find compromises and doing things that it wouldn't otherwise do in order to avoid 4-4 outcomes. And I think, Zubik, the contraceptive coverage case, may well be an example of that, where we saw, a very unusual order from the court requesting supplemental briefing, trying to find some kind of compromise position, which again suggests that, something odd is going on, that they're, struggling to try to avoid a 4-4 decision.
So SCOTUS blog statistics. Over the last decade, there have been between 11 and 24, 5-4 decisions. The conservatives won 61% of those on average. So you get an idea of how many of those things become 4-4 situations, and they have to do something else to make the case not affirmed by an equally divided court, because as much as the Chief Justice likes to avoid 5-4 cases, a term with 11 5-4s for him he can live with. A term where they essentially don't decide a case 11 times for him is unacceptable. And I think that's probably true of other members of the court. And so that gives us an idea of the ballpark area of the effects just in the merits case side, because there are effects on the cert side as well.
And we'll get to those as well.
Well, and it's just worth pointing out that when we talk about 5-4 cases on the court, when it was full, it wasn't just about the number. It was about what were the cases, in which the court was most sharply divided. And they were many of the cases that probably many of us in this room care most about. They were cases that involve, issues of tremendous controversy in our society. So we're really talking about the most kind of contested issues. We're not, with all due respect to the patent cases, but we're not really talking about patent. We're talking about the cases that are most contested. And that means that the stakes are really high. And I think it's absolutely true that there's a lot of work that's happening behind the scenes to not end up with a term in which the court really looks like a potted plant, right? Because you're going through all this process and people are briefing and arguing, and at the end of the day, it's as if you did nothing.
Yeah, I think the court, maybe generally, but especially in light of the dysfunctionality of some of the other branches of the federal government, prides itself appropriately on being an institution that works, and that actually you see them doing their work in a pretty impressive and effective way. Even though we may not agree with the result in every case. And I think the court, but the Chief Justice maybe in particular, as the head of the institution, has a great interest in not eroding that reality by having a whole bunch of cases, and maybe a large percentage of the highly contentious cases, decided 4-4. So some obviously will, but I think there's an institutional interest in minimizing that. And I guess I differentiate between sort of compromise and the sort of Zubik approach. In this sense, I don't think it's terrible in a case like Evenwell, for example, for the court to find a way to resolve the case and the issue presented in a way that isn't by one vote. I mean, the court should actually perhaps be looking to do that where it's possible. It's obviously not possible in a lot of cases. But if this pushes people to do that more, I think that's a good thing. I think I would look at Zubik a little differently, because I think what's disturbing about that order is not so much that the fact that the court issued the order, but sort of the thinking that underlies it in two senses. First of all, there was a notice and comment procedure that led to this accommodation that had almost 1 million comments filed, including comments on the very issue that the court posed in its request for supplemental briefing. And they were obviously filed by lots of people who don't happen to be before the court right now in this case. And so the notion that it's sort of an appropriate way to adjudicate RFRA claims, to have a sort of a do-over of this process, I think is very strange. But I think it's especially strange in a case where this is not just the government acting on a believer, and those are the only people with interest. The critical difference in Zubik is you have third parties, the women who have a statutory entitlement to contraceptive coverage, whose interests are at stake. And so the idea that all that gets looked at is these particular religious objectors and their views, I think is exceedingly troublesome, because you could have a case filed tomorrow that could have a whole different set of objectors who say, we have different religious views from these people, and in fact, this accommodation, even if those people agreed to it and the government agreed to it, in that particular case, doesn't work for us. And so when you have third parties whose rights are affected, you have this possibility of multiple accommodations for multiple people. And I think one of the unfortunate things about the way the court appears, at least, to be perceiving Zubik is to not take account of that reality and this sort of multiplication effect of the burden on the government of having to accommodate in this one program an infinite array of religious objections. And I go back to, sorry to go on, but if you look back at a free exercise case that involved the exact same legal standard as RFRA, called United States against Lee, where the question was, does this employer who has a religious objection to paying Social Security taxes for his employees get exempt from Social Security? And the court said, well, of course there's a burden. Requiring this person to pay is a burden on his religious beliefs, but it had no problem in about a paragraph saying this is a nationwide program. We can't have a bunch of exceptions. There's a compelling interest in having this program, and therefore we're going to hold that that even though this is a burden, it's something that has to be done. And the court's analysis in Zubik seems almost to conflate, at least the order, the substantial burden part of the analysis, which everyone certainly, if the objectors say this burdens their religion, I don't think anyone could say, no, it's not. We know your religion better than you. But to not recognize that the purpose of RFRA, like the free exercise clause before, was not to say the government has to accommodate every religious objection. Otherwise, there'd be no reason to have the least restrictive means test. And in the context of these big programs, what Lee said is, the least restrictive means is going to give the government a lot of leeway, because otherwise we can't make the system work. And so Zubik, to me, is very concerning, not because of the drive to compromise, but because it sort of reflects a real, perhaps, at least, we will find out till the decision, but a very disturbing view of what the underlying law requires.
Right, I'm going to spare you the strained segue this time and just move on. Talking about, we've talked about these cases, the potential for 4-4, but sort of other ways that the court has changed since the death of Justice Scalia. One of the sort of statistical ways it has changed is that I think since Scalia's death, they've only granted something like 5 or 6 cert petitions, an astonishingly low number. And that is obviously bad news for all of you who are filing cert petitions. It's great news for those of us in the press corps. We are going to spend the month of December in Hawaii next year because we won't have any cases to cover. What's going on? Is it just a question of, they need 4 votes to grant cert and now there's only 8 of them? Do you think it's uncertainty about sort of what lies ahead in terms of the composition of the court, some combination thereof? Any ideas? John, you are our
John is the world expert on this
docket
question.
expert.
Well, I think that it's probably a combination of both of those things, in that, it really does matter. There's 3 votes is not enough, and there weren't enough J3s. People who will join 3 votes and offer the 4th vote, put their thumb on the scale, and so not having one extra person, I think, matters. But I think that probably a larger perspective is that there's kind of more defensive denials, and that there's one more reason not to take a case. And I mean, you don't need any more reasons not to take a case, because the court is already a defensive enough institution. They're disinclined to take cert. Both Breyer and Thomas have said, essentially you can't screw up by not taking a case. You can only screw up by taking a case. And now there's one more reason not to take it, which is that, the court may blow up and not be able to decide the thing. So I think that is probably it. When you talk about, though, ways it affects courts, though, I do think, was it Justice White who said, with every new member on the court, it changes the dynamic? And I think that that's really true. And you're seeing that already, even without a new member, but in the absence of a member, and Justice Thomas asking a question. And I think also, Justice Kennedy, he is kind of a natural, he has a sort of a center of gravity in him. And when there's not Scalia making the Scalia arguments, you'll notice he's making more Scalia arguments. He said, during the Clean Water Act case, Corps of Engineers versus Hawks, he referred to, the vagueness of the Clean Water Act, and he said perhaps unconstitutionally vague. And yesterday he chimed in when the Chief Justice was talking about the ambiguity of what the hell is it, a 201? I think it's a bribery statute, but in any event, he was talking about the ambiguity of the statute, and Justice Kennedy chimed in there. And so, I think that in some ways, maybe he is kind of performing that role. It'll be interesting to see if it has any effect on the other end, because, Justice Kennedy, when he was the deciding vote in Rapanos, a Clean Water Act case a few years ago, he deprived the more conservative bloc of a fairly strong holding in the Clean Water Act context. And I don't know, it'll be interesting to see whether there's any effect on the other end in this Hawks case, or whether this is just him making sure that these views are heard and asked about during oral argument.
Yeah, I mean, I think, as others have said, what the Chief Justice, and I'm sure other members of the court as well, doesn't want in this moment of uncertainty about the future of the court is for it to seem like the court, can't do its job, the court can't function, and yet, the court really can't function the way it's supposed to with only 8 members. And every time the court takes up a case, particularly takes up an important issue or one that's likely to divide the court, and reaches a 4-4 result, that just gets further highlighted and further underscored. And so, I think for the justices, they look at cert petitions. They know that if they deny one now, the issue, if it's an important one, it'll probably come back before them, in a year or two. At which point, hopefully there will be a 9th justice. And so their view probably is we'll just wait on important cases. And so I think it wouldn't be at all surprising if we see both a smaller docket and a docket that has fewer of the really big consequential cases of the type that we've been seeing so often the last few years.
That's an important statement, that you just made, right? We're talking about a smaller docket on an ever-shrinking docket, on the Supreme Court.
Smaller than 70 to 75.
Yeah, I just think, all of these sanguine statements about, we can have 8 justices and it doesn't matter, and, we'll just kick the can down the road and all the political stuff. I think you clear all of that away, and I think, I would co-sign Andy's comment earlier about, the reputation of the Supreme Court, whether you agree with particular decisions or not, being this is a branch of government that actually gets the job done and knows what they're doing, and they do it in an effective way. And I think that it's something I've been saying since this whole controversy happened, that essentially the effort to kind of cannibalize the various branches of government and make them all ineffective may be afoot here. And I think that the court is trying to be prudent and not be a participant in its own demise, right, by taking these cases that they can't decide. I don't know. Are there also workload issues? I just think, we have one cert petition that's been rescheduled 2 or 3 times now. I just wonder if there's just a lot to do as well with the justice missing. And I know the clerks have been, scattered to other justices and so forth. But I think they are in a tough spot. This is always a tough part of the year, end of the year, when a lot of the controversial decisions come out as we come towards the end of the year. So they're very much usually under the microscope. This is their time, right? And so I think there is that concern about we don't know how long this is going to go on, and you don't want to set yourself up to be in a situation next term that's just as bad, if not worse.
Yeah, and I wouldn't minimize the sort of real-world thinking that's behind, or real-world observation that's behind the Justice White or whoever it is quote. I mean, remember, these 9 people work together really, really closely. Justice Scalia was there for more than 3 decades, and for some of them, most of them, they didn't know a court without him. And just on a personal level, and then on a how does the work get done level with this group of people, everything has changed sort of just like that. And I think certainly, my supposition is that the delay in getting some opinions out is a result of the fact that, they had a way of doing things, and people, knew people's views in the context of the 9 people that were on the court, and all of that is sort of up in the air, certainly at the merits stage, and I think at the cert stage too. I think it's, this sounds a little self-interested, but at the cert stage, I think the court has a wrong-headed view about the frequency with which issues can cleanly come up to it, and a complete misperception of the real-world impact of lower court decisions that are out there for a long time that people in the real world have to comply with, because it's the law that governs their actions, and the costs in terms of litigation costs or possible liability costs or whatever of challenging them are very high and much higher than they were 50 years ago. And so I think there's a real mismatch between their understanding of the costs of denying something, because, oh, sure, it'll come back. Actually, it probably won't for many, many years, and there'll be a lot of real world burdens on people if the legal rule is wrong in the interim.
Well, I'd go a step further and say that certainly from the perspective of civil rights litigation, the court itself has been active in some ways, making it more difficult for things to come back. And so it's not as though there's just this kind of endless round of civil rights cases teeing up all of the issues in the various areas that we can just kind of pick and choose. The field has really narrowed in part because of decisions the court has made around class actions, around standards for pleading and so forth. And so I think Andy's absolutely right that it's not kind of just a free flow, to when a civil rights case makes its way to the United States Supreme Court, that's kind of a big deal, and we shouldn't assume there's just going to be another one next year.
And I think it's just worth underscoring really quickly what Sherilyn commented on before about the shrinking docket. I mean, the court's docket now is so much smaller than it was, 10 years, 20 years ago, 30 years ago, when the Chief Justice, then judge, was nominated. He said at his confirmation hearings, he commented on how small the court's docket was and said he thought, the court could probably be hearing more cases. And yet, 10 years later, the court's actually hearing fewer cases. And so the prospect that it'll be hearing even fewer cases still because it, lacks a ninth justice is a really significant thing.
All right, I want to leave time for questions, about 15 minutes, but that leaves us with a few minutes for what I'm going to call the residual clause portion of the program. You all have your own interests and areas of expertise, and so we'd love to hear from each of you, if you're willing, about sleeper cases or trends that we should be on the lookout for either this term or going into next term. Sherilyn, I know you have.
Well, I did. I wanted to talk about criminal justice a little bit and the functioning of the criminal justice system, because I think there are a number of cases that the court has been grappling with, and it's not clear yet how they're all going to come out. So there are a few cases, two of which have already been argued. Williams versus Pennsylvania. This is a case involving a Pennsylvania Supreme Court judge who ruled on a case involving a death row convict. He had been the judge had formerly been the prosecutor, the lead prosecutor in the office, had signed off on the memo allowing the prosecution to pursue a death sentence, had then run for office, on the platform that I sentenced 45 people to death, and then refused to recuse himself from the case when this man's case arrived at the Pennsylvania Supreme Court, and that's Williams versus Pennsylvania. Foster versus Chapman is the case involving pretty blatant issues of Batson in jury selection. This is a case in which the prosecutor actually indicated on the forms the race of the potential jurors. I think there was like a BC or something for each juror who was black, and that case was also argued. But then there's some other cases percolating out there. One is the case, for which we have a cert petition, in which a man was sentenced to death in Texas after an expert witness testified that he was more likely to be dangerous in the future because he's black. And then the final case is a case called Pena Rodriguez versus Colorado, and the court did take cert in that case. Yeah, they
exactly.
did for next term. And this is a case in which, when we took the rare posture of filing an amicus brief in support of the court granting cert, because this is a case involving blatant juror bias. Where two other jurors revealed that one juror had talked about the defendant and said that because he was Mexican American he was inclined to do X, Y, Z, and the question is whether or not the no impeachment rule can actually constitutionally be applied in a case in which there might be a violation of the Sixth Amendment right to an impartial jury. All of these cases are important because of the world we're in right now, where we're focused so much on the criminal justice system, on the right and the left, and where issues of policing reform and illegitimacy in the criminal justice system are very much in the fore. So all of those cases seem to me quite important, but they all then have to be viewed against the backdrop of a case that's gotten almost no attention, but which I think is actually one of the most important cases decided by the Supreme Court this term, and that's Mullenix versus Luna, which is a case out of Texas decided in November, 8-1. Justice Sotomayor was the dissenting justice, and it involved a case of a police officer shooting a fleeing suspect.
This is a summary reversal, right?
Yeah, and
yes.
this is a case in which there was a car chase, and the police officer was standing on a bridge over the as the car was about to come. The police department had put up the spikes to kill the tires of the car. The officer was told by his supervisor, "Don't shoot. Make sure that let's see if the spikes work first." This officer had in the past been kind of reprimanded, but told that he wasn't sufficiently proactive as a police officer. And so as the car came through, he shot his weapon through the windshield and killed the driver and said, I was only trying to stop the car. And after he shot through the windshield, he turned to his supervisor and said, how's that for proactive? So even the Fifth Circuit thought that this officer was not entitled to immunity, and yet the Supreme Court saw it differently. Here's a case in which Justice Sotomayor was really agitated, and I think it's important because people sometimes fail to recognize the diversity she brings to the court, and it's not actually that she's Latina. It's actually that she was in the Manhattan DA's office. She has an incredible amount of experience with police officers, police investigation, police testimony. She also was a trial court judge, and so she kind of knows whereof she speaks in this context. And she, in that case, talked about the Supreme Court, by that decision, reinforcing a culture of policing, which is, been the language, kind of out in the public about policing today. So this case didn't get a whole lot of attention, but it really was an important case that spoke right into the moment that we're in around policing reform and so forth. And so when I see that case, I have to then put it together with these 4 other cases and say the Supreme Court is at least wading into this area fairly deeply to look at the issue of race in the criminal justice system, and how all of the tea leaves are going to shake out. We're going to know at the end of next term after the Pena-Rodriguez case is decided.
Yeah, I actually think, I agree entirely. I think criminal justice reform is becoming a increasingly frequent issue at the court, and it's one where it's, interesting. Justice Kennedy has, both in opinions and off the bench, spoken about, mass incarceration, prison conditions, solitary confinement. These are issues that I think are of real great concern to him. He basically asked litigators to bring a solitary confinement case to the court at the end of last term. There was, in fact, a petition pending. We had filed a brief in support of it, and then Virginia executed the individual, mooting the case before the court could decide whether to grant the petition. There's another petition pending now that the court conference last week. It's been relisted for consideration of this week's conference that raises a couple of claims, one of which is what's called a lackey claim, where someone's been held on death row for an extended period of time. This individual's been on death row for decades in solitary confinement, and so it'll be interesting to see whether the court takes up that case. And it's also interesting. There were a couple of criminal cases that were decided very early in the term, and I feel like they've kind of gotten lost in all of the
right, because they were a really long time ago.
Yeah, right. But so Hearst, which is a challenge to Florida's death penalty system, Montgomery v. Louisiana, which dealt with juvenile life without parole sentences, and those were both wins from the perspective of people looking for criminal justice reform, and they were wins that were not 5-4 or 5-3, if that's the new, maybe that's a new 5-4. The Hearst was a 8-1 decision. Justice Alito was in dissent. All the other conservatives joined with the court's progressives. And Montgomery v. Louisiana was a 6-3 decision in which both Justice Kennedy and the Chief Justice joined them. So I think, we are seeing interesting coalitions in the court and I think a real focus on those kind of issues.
Well, I don't know if I have any sort of trends, but the cases that, for me, that are most interesting are far off on the horizon, the cell phone data cases, which I thought that there was a decent chance, or not a decent chance, there was some chance of one of those being granted this term, but the Fourth Circuit is rehearing that on bank, and so it may not happen. But this is one area that we've lived with for years, with this idea that data that you expose to third parties, you don't have an interest in privacy, a privacy interest in. Justice Sotomayor, in something that has nothing to do with her being a Latina, is calling that into question. I think that there is, potential, and the cell phone case from a couple terms ago does show that the justices are, keenly attuned to this and that they're kind of reconsidering. And I think that that's something we might see in the next, 2 to 5 years is some interesting opinions along those lines, just reconsidering that sort of third-party records doctrine, and when it applies to digital things and things like, internet addresses and things like that. So.
Andy, the last word before we move on.
And Congress has actually yesterday took some steps in that direction that may mean the court doesn't have to. I was going to talk about patent cases, but I won't do that.
So you're going to talk about ERISA cases instead?
Yes, no, I don't know ERISA. No, I guess I would. What's striking to me, and I haven't attended a lot of them, is we talked about the sort of the death of Justice Scalia and its impact on the cert process and on the merits decision-making process. But I think it's quite stark in oral argument. Really, oral argument is a very different kettle of fish than it used to be, because his voice was obviously very prominent, and I think you can see the court sort of working out how this new reality is going to be. I think for many people, and since I have argued cases both on the sort of pro-corporate defense side, but also on the progressive side, the old court, you had a lot of questions and support if you were if you were arguing for the government in a criminal case or in favor of a class action defendant.
Some might call them softballs.
And maybe a lot less support, if you were arguing in favor of a criminal defendant or someone who had been wronged by the immigration system. But I think that's actually changed quite a bit in the new reality, not just because the amount of people asking questions on both sides and the frequency with which they ask them is quite different. And it's just interesting to see. I always thought that the sort of public perception of argument was skewed because there were a lot more questions often coming from the more conservative side of the court. And I think that may have skewed how people thought the oral argument went or how the case was decided. And I think that's changed pretty significantly. But I think there are interesting questions, as John, I think, said, about the dynamic amongst the justices for our oral argument. The other thing I'll say about 4-4 is it just is interesting to me in the sort of punditry world. I think it makes it easier for pundits because in every case, it seems, that has any political saliency, people just automatically say, well, that's going to be 4-4.
Justices are deeply divided.
And the justices are deeply divided. And of course, when there were 9 justices, people didn't have that option. So they actually had to figure out which side was going to seem to have done better, which is a very difficult process in any event. But it's just interesting to me that the default of the cases that have been argued in the last couple of sessions has been, seems like the court is going to be 4-4, when for the reasons we've talked about, that seems like not the most likely outcome.
Excellent. All right, Kelly, do you have a microphone or? Excellent. Questions for our panelists. Tony.
Thank you. Just following up on the conversation about the impact of an 8-member court, is it changing the conversations you have with your clients or your constituencies in terms of cert grants or amicus briefs? Are you saying, let's, slow this down, or let's not file, or let's not swing for the bleachers, or how is it changing things at all with your clients?
Well, only in that. So if I think, for example, about our case in Texas, the voter ID case, which is going to be heard in bank shortly. Only in explaining what a timetable might look like and what a result might be, right? So we've just had to factor in the possibility that whatever the Fifth Circuit decides in bank may end up being the decision if the case is heard in the Supreme Court while it's still potentially evenly divided. But we're in the thick of cases, and so there isn't really much we can do. But we do feel that we have to explain to our clients and to the communities of folks that we serve, what the possibilities are. If this situation doesn't get resolved, it's actually not going to be resolved before the fall, and certainly not before November, most likely. It could, but it's unlikely. And so we just feel like we have to lay out that reality so that people understand what the significance is at the Court of Appeals, particularly in bank.
I think, obviously clients ask about it, but it's awfully hard in most cases to say, you're dead now, or, this is great for you, or whatever. I think it's awfully hard to game it out. And, if you think about it, petitions that are going to be filed now, may well not be decided, depending on extensions and other things, until at least it's clear who the president is going to be and maybe even who the nominee is going to be. So it's awfully hard to say, for these cases, we have some magical calculus that will tell you have a better or worse chance of winning. I think if people have a good legal argument, they have a good chance of winning.
So we've already seen some people figuring this out for themselves quite publicly. Like, for example, the Dow case, the urethane class action, where even before the Tyson Food decision, they, and this I think was affected somewhat by the fact that they're in a merger with DuPont, and they just saw that they saw the writing on the wall and they quit. I also have one of my clients, believe it or not, is a hedge fund, and they periodically just call me up and ask me to handicap outcomes. And one of their cases that they were watching was the Clean Power Plan case, because it was very interesting when the court granted a stay in the Clean Power Plan case. And with Scalia's death, there's not really any prospect of that case, of that challenge winning, unless, there's a much smaller prospect of them winning, unless things line up just right. So I mean, that's one thing that has been kind of interesting. And there are many environmental challenges that have a completely different complexion if Justice Scalia is not going to be a member of the court that decides them. But that's something that goes kind of all the way down. The Clean Power Plan was interesting just because, Sri Srinivasan is on the panel that's going to be deciding that. And there was the whole other weird angle of, he wouldn't be able to sit on the Supreme Court that reviewed his own decision in that. And so, the nomination of Garland at least resolved that one question mark.
And that's sort of a perfect example. The D.C. Circuit is going to hear that case on June 1st. It'll get decided sometime in the ensuing months. Whoever loses will probably file a petition for rehearing en banc. That'll take a little while. Cert petition gets filed. There's a pretty reasonable chance that President whomever will have nominated a justice to fill the 9th seat. So it sort of all may depend on who that person happens to be.
Yeah, that's why the voting rights cases have a certain sense of urgency, because people want to
Right.
know what's going to happen in time for the November election, and that's a very short
Right.
timetable actually. So,
Anyone else? Bob?
Thanks. I was wondering what you think about the possibility of rehearing in any of the cases, maybe the contraceptive case, for instance. And if so, when would that happen? Would we have known by now, or is that a last day of the term decision?
I mean, it's difficult. Personally, I think it's unlikely. Particularly given the posture we're in, where it's unclear when exactly we're going to see a 9th justice. If, Senate were doing what it was supposed to be doing and giving Judge Garland a hearing, and we thought we'd have a justice confirmed soon, I could imagine them holding some cases over for next term. But, given that we might not have a 9th justice, confirmed until well into next term, I think that could, from the court's perspective, look a little awkward, and again, just highlights the weird position they're in, that they don't have a 9th justice, they can't really function, and so my guess is that they won't, but you never know.
Yeah, I think traditionally, at least in some cases, it's been an end of the term, last order list event. But that, for the reasons Brienne gave, that doesn't really help, because it almost certainly those cases would then be argued before the end of the year, and it seems highly unlikely that before the end of the year there's going to be a 9th justice, so it would be the same people hearing the case again. They could certainly order re-argument and put it off, but it would all be awfully odd since, as Amy said, they're going to have nothing to do in December.
I got a briefing schedule of 1 year.
Unless it's a peculiar case where they've spotted some other way of resolving the case that they can do with 8 justices, but again, that'd be unusual.
All right. Garrett, we have a question in the back.
Hi. One thing that's been going on since Scalia died is that you've had this extraordinary moment in which the Senate majority is sending the message to the court: you are a part of our partisan majority. You are expected to do your part. We will not allow you to function if you don't. And you have Chairman Grassley getting up and basically taking on the Chief Justice as insufficiently conservative. I'm curious, what's the long-term effect of this going to be? You look back at other times when the court has really gotten crushed in partisan politics, they have long-term effects. What do people think?
Well, I think it's disturbing. I think the court's legitimacy obviously depends to a large extent on it being perceived to be above politics. And, while we can all say that the real world they're not monks and cloistered people insulated from the real world, I think that is often and probably virtually always the reality. But I think saying you're a political institution and you sort of have to toe the party line, if that's what the perception is disturbing, because I think that has a natural effect of people then saying, oh, so they really are just another political institution, and it all depends on whether you're a Democrat or a Republican appointee. And I think it doesn't help with the legitimacy of the court in the long term.
It's not clear to me, though, that Grassley's pronouncements, and I think you've described it quite well, like this effort to try to bring the court into kind of the partisan realm, is actually being received by the public. I mean, you've seen all the polls, right? Most of the public thinks that, Merrick Garland should get a hearing and a vote. So it's not as though the Supreme Court's never been perceived as being political before. Probably Bush versus Gore was the nadir, but I think that in some ways the court may come out stronger from this, because I think the general public thinks that it's fair to give this president, to ensure that he has his right, his constitutional right to nominate, to give this particular nominee a hearing and a vote, and so I think actually it's, and for the court to be kind of going on about its business in all the ways that we talked about, even if it's compromised, I mean, I think that's not like they wouldn't go on about their business, but it's smart. I mean, you remember the comments that first came out, when Justice Alito said, we will shoulder on, and Justice Breyer says, what, so what? We're just going to do our job. I mean, whether or not that was true or bluster or whatever it was, I think there is something to the court looking like it is trying to do its job and toe the line, that ultimately on the other end of this may strengthen the court in the eyes of the public as a less partisan institution, shall we say, than the United States Congress. I don't think the court, in terms of perception, is being weakened by this. I do think Congress is being weakened by it, but I don't think that the court's being weakened by it.
Well, I think whether the court is weakened or not is going to depend to some degree on what they do and how they decide cases in the years ahead. I mean, I think it's clear this has to be the Chief Justice's worst nightmare, because I think if we know one thing about the Chief Justice is that he does care very much about the court's reputation, about its institutional legitimacy, about his reputation as Chief Justice, and I think that's a concern that has influenced him in some cases to put law over where his ideology might lead him. And I think if anything, the fact that the court is being pulled into this partisan fight, will, at least one hopes, lead him and other justices to have a greater sensitivity to that concern and, greater appreciation for the importance of, just following the law and doing what the law and the Constitution require.
Okay, I had a question in the back, and then. Sorry. She's next.
I was curious, in light of the Reuters report from 2014 about the echo chamber, the small elite group of practitioners appearing before the Supreme Court who all uniformly have quite similar backgrounds, very few people of color. Amy, you were one of the few women listed there. Is this the direction, in your opinion? Is the court going to continue down this direction? And if so, what does that mean for the cases that the court is going to take and the evolution of the law?
Well, not if I have anything to do about it. I mean, I think, obviously we all read all the stories, and I think Justice Kagan said she thought it was great, that there's a professionalized Supreme Court bar. I think there are two things happening in that during oral arguments, certainly in that chamber. One is that you have a set of justices who have a remarkably similar background in terms of their professional life, and you increasingly have advocates who have a remarkably similar background in terms of their professional life. And I do think that, frankly, it's important. In fact, I think we get the best judicial decision-making when you have a variety of perspectives and voices that are interacting. I do think it matters. It would be, bizarre for me to be leading the organization that Thurgood Marshall founded and not believe that is true. And we've just been sitting here talking about what it means to have Scalia's voice, one person, absent from the court, and the way it's changed the dynamic, the way it's changed how the court works, the way it's changed the cadence and the and the questioning at oral argument. And I've talked about what that can mean for someone sitting, listening to the oral argument. So to pretend that it doesn't matter who's speaking in that room, whether it's from the bench or from the podium, I think is just insupportable. So we think it's pretty important. Now, to be fair, given what the composition of the court has been, I can honestly say that we have not been anxious to get many cases before the Supreme Court in the past, frankly, because it has been largely a conservative Supreme Court. We were last there as litigants in the Shelby County case, in the Voting Rights Act case, and we know what happened with that case. But we always feel that we have a good chance. If we have a good case and good arguments, we have a good chance, and so we're prepared to go. And the court then gets to make the decision depending on the size of the docket they want, whether they're willing to engage that issue, whether they have a misperception about, that they don't have to do it now because it'll come back, whether there are 4 justices who want to grapple with the issue, whether there are 4 justices who understand why the issue is so important. So for us, that's an important question.
Can we squeeze in one more question?
I just had a quick question on Garland. How you all see this playing out? Does it fizzle? How do you keep the momentum from the administration's perspective? And then the question of would there be, if it came to that, a renomination? Any thoughts on that?
Well, I think, he's visiting senators. I think lots of people, both in Washington and in the states, are talking about the institutional damage, as Sherlyn said, to the Senate that's being done to the country of only having 8 justices, and what a problem that is. And I still think that there's quite a lot of discussion out there. Washington, we tend to move on quickly to the next thing, whatever it is. But I think out there in the world, there's a lot of discussion about the real-world adverse effects. And I think another real-world adverse effect that people are talking about to some extent is here's this man who's given basically his entire life to public service, who, although largely has not been criticized or attacked, has been criticized or attacked by some people, and who really hasn't been given the sort of basic fairness of the forum that everybody gets to defend themselves, which is the opportunity to have a hearing in front of the Senate and for people to address charges that are being made about him and to answer questions that people have about him. And I think there is a sort of in addition to the institutional harm, there's sort of a basic fairness in saying to someone who has, in a variety of roles, given so much time to the country, we're not gonna let you be out there and be the target of attack ads and things like that without having an opportunity to respond.
It is a pretty stunning thing, I think, to hear people criticizing him and saying that we don't know enough about his views from beyond the court, and then not giving him the forum that every Supreme Court nominee and every judicial nominee is supposed to have to state those views. And I think another thing that's going to keep the conversation going is that, as the term goes on, as we move into next term, the Supreme Court itself is going to be, through its actions, a constant reminder both of the need for a 9th justice, and also, at some level, the Supreme Court is continuing, despite the burden of not having a 9th justice, of trying to do its job, and that's, contrasted with the fact that the Senate is totally unwilling to do its job under the Constitution of giving the president's nominee a hearing.
Given who Judge Garland is, I think we should also recognize that there is a message being transmitted to other highly qualified, highly competent people who think maybe they want to be on the Supreme Court one day. This is extraordinary that for all of the reasons that you've just heard, that this person would not get a hearing. To the point of, I'm meeting with him this morning to tell him why I won't meet with him. It's just, it's pretty extraordinary. And my own view is that, initially it was and remains meant to be a continued delegitimization of this president, which has been going on since 2009, to be perfectly frank. But I think seeing it play out in this way, in a way that taints an institution that all of us believe in and that has managed to maintain through ups and downs a strong reputation with the public, and that it is also tainting the experience of a person like Judge Garland, who, given his background and what he's done and who he is, this is the Chief Judge of the D.C. Circuit Court of Appeals. This is an extraordinary disrespect to someone of that stature. And I don't think we shouldn't recognize that message is also being transmitted to others. It's being transmitted to others, who are on these, mysterious short lists that come up every time there's a potential opening about what are they prepared to subject themselves to? What are they prepared to be exposed to by being selected? Now, of course, they won't be selected by this president, and that may change, the calculation immeasurably. But still, a line has been crossed that I think is not very easy to just forget.
John, do you want the last word before they start playing the music like at the Oscars?
Well, I think when you're talking about just discouraging nominees, I think that what Bork and Thomas went through is a lot more likely to discourage nominees than what Garland is going through. I think it's easier to sit on your hands and be ignored because of, you are candidate X rather than because of attacking you. And, Justice Alito's wife cried during the confirmation hearing, which suggests that that wasn't exactly a kid gloves affair. Just in terms of brass tacks, there are two times when people pay attention to the Supreme Court: during argument and during hand downs. Arguments are now over. Hand downs, and especially whether they're 4-4s, may draw attention, but I don't see pain being inflicted on the Republican senators who are refusing to give them a vote. The thing that will be interesting to me is to see whether they give them a confirmation hearing after, if Hillary Clinton becomes president, if they'll be like, what we said about leaving this to the voice of the American people, we really think we can decide this now. Or, now that they've said we want another Democrat, let's just confirm the one, the nominee given to us by the last Democratic president. And it'll be interesting to see. I mean, already, South Carolina Senator
Lindsey Graham.
Lindsey Graham has already said, that'd be inconsistent. But I think that there are plenty of other people. I mean, people don't normally attribute real principle to politicians, as demonstrated by the fact that, people switch position on how holy the filibuster is every 4 years. And it'll be interesting to see whether people, suck it up, or whether Republicans suck it up and say, what, Merrick Garland is a great individual, let's get him confirmed. The court really needs 9 members. So it'll be interesting to see what happens there.
I think just to pick up on Sherilyn's point, because I think it's important, Supreme Court justices were the exception in terms of the hearing and the way they were treated by the Senate. This is what Judge Garland is going through is the rule for nominees to other federal courts. And I think it is really problematic. And if you know someone who is in this situation where your life is basically put on hold maybe for a year, till you find out, or longer, whether you're going to get confirmed. Most people can't economically or emotionally put themselves through that. And I think this process is incredibly damaging to the prospects of getting the people on the judiciary we all want. And the fact that it's now happening at the Supreme Court level sort of infinitesimally, I think, expands the reasons why people are going to say that's just not for me.
For example, John Roberts didn't get a hearing in 1992. From January to the end, didn't get a hearing. Pam Reimer didn't
Just
get a
like
hearing.
Elena Kagan.
Margaret McEwen. No. No, my point is.
Neither of them are
All right, and we are not going to resolve this dispute today. So please join me in thanking the Constitutional Accountability Center and our amazing panelists.